Are you expecting Ms. Willingham in person? I don't see her online.
I was expecting her to be in person today. So.
Okay. Ms. Nelson, can you check with Ms. Willingham?
Yes, I will.
Thank you. So Mr. Huey is on the trial calendar. Mr. Stokes is just one you've managed to work out.
Yes.
Okay. Is there, Mr. Huey will be walking in, Mr. Stokes is in custody.
Correct.
Okay. Well, I guess it will just depend. If we get Ms. Willingham before we get Mr. Huey, then we'll do Mr. Stokes first.
Thank you, Judge.
Judge, Miss Willingham is on the elevator. She's on her way.
Thank you. So why don't we bring Mr. Stokes out? Is that all right, Ms. Wood?
That's fine.
Ready for him? Okay. And he can come on out and we'll be ready to go.
Hey, so just because I didn't have this printed out, this is the second case, but that'll be dismissed and that's changed to criminal trespass like we talked about, but just so you can see it. Okay?
Hey, Ms. Willingham. No problem. We're just getting everyone in place. We're going to do Mr. Stokes first. Mr. Huey may be on a different elevator. You'll let me know when you're ready.
Oh, I'm ready.
You're ready. Okay. You usually have to like turn a computer on or something.
Oh, no, not today.
Paper-based today? All right, great. Well, let's go on the record then, please. We've got Mr. Stokes out here with his lawyer, Ms. Wood. Hello, Mr. Stokes.
How you doing?
I'm all right. How are you doing?
Good.
Good. Mr. Stokes, you have two cases and Ms. Wood tells me you're prepared to enter a plea in both your cases. Is that correct?
Yes, sir.
In a moment, Ms. Willingham, who's the prosecutor handling your cases, is going to put you under oath. You'll need to answer all her questions and mine, and we'll both have some questions, truthfully and completely. If you at any point have questions because something is confusing or it's not going the way you and Ms. Wood discussed, will you let me know?
Yes.
Okay, great. Ms. Willingham, when you're ready.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name, your age, and your date of birth.
My name is Stokes. I'm 19. My birthday 10/25/03.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
10th grade.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the documents that charge you in these cases?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiation as to 23 SC 186018, count 1, 3 years to serve 180 days with the balance probated. Count 2, serve 180 days. Count 3, 4, and 6, counts 3, 4, and 6 would be non-priced, and count 5 would be 12 months probation. All counts would run concurrent. As to 23 SC 187631, count 1 would be reduced to criminal trespass under OCGA 16-7-21 with 12 months probation to be consecutive to 23 SC 186018. And count 2 of that I'm sorry, I said that backwards. Count 2 would be non-priced, and that is as to 23 SC 187631.
So the indictment ending in 631, entering auto is being reduced to criminal trespass, misdemeanor, and count 2 is null prost.
Yes.
Okay.
Okay. Is that what was discussed with you?
Yes.
You're pleading guilty today to aggravated assault strangulation with a minimum of 3 years and a maximum of 20 years. Battery family violence with a minimum of 1 day and a maximum of 12 months. And 2 counts of criminal trespass, each with a minimum of 1 day and a maximum of 12 months. Do you understand you are not required to plead guilty to the charges unless the grand jury has heard sworn testimony and then charged you in an indictment?
Yes.
Is that something new that you say?
It's only because one of his cases it's an accusation.
Ah, okay.
The first case, right?
The entering auto. yes,
Yeah.
that
'Cause I
was-
ain't do that. I ain't own it down.
Okay. We'll get to that in a minute. You mentioned, Ms. Willingham, that Mr. Stokes is pleading to 2 counts of criminal trespass, but that's 1 in each case? Got it.
Yes.
Okay.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is a total of 4 years to serve 180 days, and that's for both cases. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 23 years?
Yes.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today? This case is not on for final plea, I think, until,
No.
I know it's a later date,
Right.
so I just want.
Understood. So, Mr. Stokes, because of where we are in the process of moving your case towards trial today, if I sentence you to more than what's been negotiated, you'll have the ability to back out if you want to. So I'm gonna just make it up. If I sentence you to a year, right now, what's been negotiated and what the 2 sides are asking me is 6 months, 180 days, 6 months. But if I say, I've heard about this and what you did to Ms. Grant, allegedly, I think you need to be in jail for a year, which I'm able to say. You will be able to say in response, no, thank you. I would rather go back and wait till I can have a trial because I got a good defense and a jury might say not guilty, and I'd rather have that trial. So I'm not saying that I'm not going to go along with the recommendation. The important piece is that you have the ability to withdraw your guilty plea if the sentence that I impose is more than what Ms. Wood is asking for on your behalf. Does that make sense?
Yes.
Okay, great.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as to 23 SC 186018, you are to have no violent contact with Zariah Grant, ZARRIAH, Grant common spelling, complete family violence intervention program, complete your GED, actively seek and maintain employment, complete 60 hours of community service, and as to 23 SC 187631, the state would be requesting $1,200 in restitution to be paid to the victim, Kyle Sweeney. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I've asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you're pleading guilty? And we'll take those one by one. As to 23 SC 186018, and that is the indictment involving Ms. Zariah Grant, did you in fact commit the offense to which you're pleading guilty?
I'm just pleading guilty in my best interest.
Okay. Are you entering your plea of guilty pursuant to North Carolina v. Alfred, meaning that you may not admit guilt to every element of the crime charge, but believe it's in your best interest to plead guilty today?
Yes.
As to indictment or accusation 23 SC 187631, and that is the entering auto, did you in fact commit the offenses to which you're pleading guilty?
No. I'm pleading guilty in my best interest.
And I'll read that same paragraph again one more time. Are you entering your plea of guilty pursuant to North Carolina v. Alfred, meaning that you may not admit guilt to every element of the crime charge, but believe it's in your best interest to plead guilty today?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. For the felony offenses, you will have 4 years, and for the misdemeanor offenses, you will have 12 months from the date the sentence is entered to file those petitions. Do you understand these time limits?
Yes.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes.
Do you understand if you are found in possession of a firearm, you could be charged with another felony which carries up to 10 years in confinement?
Yes.
Should the state proceed to trial in indictment ending in 186018, the state would prove beyond a reasonable doubt that on June 6, 2022, in Fulton County at 1041 Irish Street, Southwest Atlanta, Georgia, defendant Stokes and victim Zariah Grant got into a verbal argument when Stokes discovered Grant had been communicating with other men from her phone. At that time, Grant's juvenile sister, AT, was in the room with them. Amidst the argument, Stokes got on top of Grant, placed both his hands around her neck, and began to strangle her. Grant said that she had difficulty breathing and felt Stokes' grip getting tighter. Stokes then bit Grant on the shoulder, leaving a dark visible bruise. Stokes then got off of Grant and smashed one of her iPhones. Grant then grabbed her sister and ran to her neighbor's house, Henry Campbell, to call 911 from their phone. When Grant was safely inside, she watched from Campbell's glass door as Stokes poured the contents of her purse into the street. Stokes also smashed Grant's second iPhone in the street. Stokes then went back into Grant's house and retrieved a knife. Stokes returned to Campbell's house and began kicking his glass door. Moments later, he threw the knife at the glass door, causing it to shatter. Stokes then fled on foot. As to
You gave the date of June 6th. The indictment says June 28th. Doesn't sound like there's going to be a big conflict about this. But the police report shows you June 6th. Okay. All right.
And as to indictment ending in 187631, on July 17, 2021, Lieutenant Welch was driving on Washington Street in an unmarked police car when an alarm of the vehicle began to go off as he was driving past it. When he looked at the vehicle, he could see the front window on the passenger side had a big hole in it. As he continued a little past the vehicle, he saw two black males outside of the vehicle looking at each other. He then began to turn his vehicle around, and the males realized he was an officer. The males then took off on foot. Mr. Stokes was caught and taken into custody while passively resisting arrest. Mr. Stokes had scratches on his arm and was bleeding when he was caught. There was also a small amount of blood on the Escalade. As stated before, the window was busted and only did not shatter due to tint. The center console was open as well as the glove compartment. And that Washington Street was in Atlanta, Georgia, and Fulton County.
All right.
And Your Honor, the state has spoken with both victims. As to Zariah Grant, if the court recalls, we had a bond hearing in this, and Ms. Grant had been actually in communication with the defense counsel, and that's how we were able to then make contact with her. She would like for the defendant to be able to come home so that they can raise their child together, and she needs his financial support. The state explained to her that we were not inclined to dismiss the charges, and based on that, we felt that this was the best resolution in this matter.
Is AT their child, or there's another child that they share?
Oh,
it was her sister. Right,
yes.
right.
And as to the entering auto case, Mr. Sweeney, I have spoken with him, and this happened so long ago. His main concern is just that he actually paid out of pocket to get his window fixed. So his only concern was really restitution.
Which was how much?
I spoke with him and I talked to Ms. Woods. He did not have the exact receipts on him. He believes he paid upwards of $1,500. However, I explained to him what we were trying to do to resolve the case, and he's more than happy to just take the $1,200. However, if Ms. Woods is ultimately wanting to do a restitution hearing, he has no problem with that. He would just need a little time to be able to gather the receipts, since this did happen quite some time ago.
I may have missed you say it then. Mr. Sweeney, thinks it was over $1,500. You said $1,200. That's what was negotiated, or?
He's okay with $1,200. So I told him that is what I would speak with Ms. Woods about.
Okay.
So if the defendant is amenable to that, then there wouldn't be a need for a restitution hearing. However, I did explain to him that and Ms. Woods and I only spoke, I know she still needed to get back with her client about it.
Sure.
But he does understand that if that is not something that is agreed to, we will have a restitution hearing. He just asked that it be set just a little bit out.
Yep.
It was so long ago, and he'll have to find those receipts.
Understood. Okay. So no violent contact with what special conditions of probation? No violent contact with Ms. Grant.
No violent contact with Ms. Grant, complete family violence intervention program, complete his GED, actively seek and maintain employment, and complete 60 hours of community service.
All right. And then some amount of restitution, either I'm setting a number that there's no objection to, or there's agreed upon number, or we have a restitution hearing.
Correct.
Got it. Okay. Do you have any information on criminal history? We've got someone from probation who I will ask in a moment, but we don't have pretrial services this morning.
Your Honor, and
It's okay if you don't. I just was curious.
I do remember looking into it for the bond motion, so I know that the case, the entering auto was out there pending at that time, and there was one other case that it looks like maybe was in state court, but it didn't have a resolution. So but other than that, there was no felony.
Okay, well, let's find out from Officer Sadler. Good morning.
Good morning. How are you?
I'm well. Do you have any criminal history information for Mr. Stokes?
No, Your Honor, he doesn't have a felony probation record with us.
Okay. All right. Appreciate it. Let's turn to you, Ms. Wood.
Thank you, Judge. I just wanted to confirm, I believe there is only, so there's a total of 3 arrests, including these 2 cases. There's only 1 other, and I think it's still pending, but it is in state court.
All right. It sounds like there's not 3 other felonies that we don't know about, that we are considering the bulk of things Mr. Stokes has gotten mixed up in.
Thank you, Judge. Mr. Stokes is 19 years old. He is a lifelong resident of Atlanta. He has 1 child, as you heard about, that he shares with Ms. Grant. He has a 10th grade education from South Atlanta High School. He was working on his GED before this most recent arrest. He says he's very close to finishing that, and I have explained to him that that will be a special condition of his probation. He had done some work with a construction company called High Rise Remodeling prior to the arrest. He believes that he can return, so we are hopeful that he will be able to re-enter society successfully. Judge, we are asking for a couple of things. First, I'm asking the court to consider waiving his probation fees so that he can focus on paying for the family violence intervention program. I'm also requesting a restitution hearing on the second case, Judge. I understand $1,200 or $1,500 might not be a lot, but for this situation, I think that it would be, and plus I haven't seen any proof of receipts or anything, so that's why we're requesting a restitution hearing. He has been in 189 days. We would ask for credit for all of that time. And finally, I have spoken to Ms. Grant numerous times. She's so eager for him to get out, Judge. So we would ask that you accept the state's recommendation in this case.
Okay. Mr. Stokes, what is the name of your child?
DeMarley Stokes.
DeMarley?
Yes.
How do you spell that?
DAMARLIE.
And is DeMarley a boy or a girl?
A boy.
How old is he?
2 months.
Whoa, he is teeny. You've never met him.
No.
Oh my gosh. Okay. And Ms. Grant is the mother. Okay. And does she have other kids?
No.
How old is Ms. Grant?
19.
You're both 19. How'd you meet Ms. Grant?
Through a friend.
When this situation happened in June, were you all living together or do you live in separate places?
We was not staying together, but I was at her house. at the
Okay.
time.
When you get out, whenever that is, where will home be for you?
I could either go stay with my dad or my godmom.
Which is a smarter, safer place for you to be?
Both of them are safe, but I'd rather go to my dad's house
Why?
because I know he's gonna make sure I stay on the right track.
Okay. And where does your dad live?
Jonesboro, Georgia.
Okay. How would you get from Jonesboro to what?
He got a car.
Okay. Do you have a driver's license?
Nah, my dad gonna bring me.
So where does Ms. Grant stay? Does she have her own place or does she stay with family?
Tell her mom.
How would you get from, and is that in Jonesboro or is that in Atlanta?
Yeah,
Somewhere near where this situation happened?
yes.
Okay. How would you get from Jonesboro to Ms. Grant to help take care of DeMarley?
Either Uber or my dad would take me or my stepmom.
Does your dad work?
Yes.
What does he do?
He on work at the Congress Center.
At the World Congress Center?
Yeah.
Okay. So he will get you to work, he will get you to Ms. Grant's.
More than likely, I'm gonna be working with him in the city. So
Oh, what does he do at the World Congress Center?
he be putting up shows like stage and stuff.
Okay, so is that the construction work that's a,
That's my stepdad who got the church pimping.
okay. So you got several potential parents who could help you find some work.
Yes.
All right. So tell me why it's an offered plea in the case involving Ms. Grant. I'm not so focused on the Cadillac case, but the situation with Ms. Grant concerns me just because it sounds like you got upset, and the way you handled being upset, you got a little rough with her, and that's not okay. And you're saying it's an offered plea. You're saying it didn't happen or it didn't happen exactly like,
Happened like what she said.
okay.
What she said happened.
But you and Ms. Grant did get into some argument.
Yeah, we got into an argument. I ain't put my hands off.
Okay. What were you arguing about?
We were arguing about somebody texting my phone, actually.
Oh, you were texting other ladies?
Yeah.
Okay. That must have been tough for Ms. Grant if she was
Pregnant.
with your kid and her kid.
Now you get the bigger picture.
Okay. Well, I don't know that it's a better picture. It's a different picture. All right. Well, Mr. Stokes, I want to make sure you understand I can accept an offered plea. That's when a defendant says, you know what, Judge? Something bad may have happened, but it wasn't quite like the state said. But I don't want to either risk going to trial or wait going to trial. I would rather take this deal right now, and that you, Mr. Stokes, have decided that that's in your best interest. Does that describe your situation?
Yes,
You understand this still shows up as a conviction.
I know.
It's going to be on your record. It's not a non-event just because you say, oh, offered plea. You understand that?
Yes.
Is this a first offender
I
situation?
was just gonna ask, I forgot to mention that. I'm asking for first offender treatment in this case. Judge, he's 19. He has his whole life ahead of him. We've gone over the pros and cons, and he has indicated that he wants to ask for first offender.
Okay. And he'd be using first offender on the felony plea?
Yes, Judge.
Okay. Ms. Willingham, do you have any objection to Mr. Stokes being sentenced as a first offender? Mr. Stokes, I have to cover it with you anyway, so I know you've heard about it from Ms. Wood, but first offender is primarily an opportunity. If I sentence you as a first offender, it's not a conviction. So if you're trying to get a job at World Congress Center and they hand you a piece of paper and says, hey, are you a convicted felon? You say no to that because you're not. You're under a sentence, but it's a first offender sentence, and that's not a conviction as long as you do well on probation. So the upside is not a felony conviction. If you successfully complete your sentence, when it's done, it can be expunged from your record like it never happened. And something happened, and you and Ms. Grant are going to need to handle things differently going forward. But here, it would be not on your record, which helps with school, it helps with work, all sorts of good ways. But there's a risk. If you're not sure at the young age of 19 that you're really in a position to stay out of trouble with the ladies or whatever's going on, this could bite you, because if you get, I'm making this up, but if you get arrested 6 months from now and you actually have your arm in the window of a Cadillac and it's not your Cadillac, not only would you have this new case, but the state could ask, and I might very well take away your first offender status. I resentence you. You've already admitted you did these things, even though it's an offered plea. And I could resentence you all the way up to the maximum, which is 20 years plus a few more. I'm not saying I would if what you got in trouble for in the future was breaking into a car. I'm not going to sentence you to 20 years, but I could use your new arrest as a reason to resentence you in this case, your case with Ms. Grant. So that's a risk. You are in the best position to know, am I ready to make different choices such that first offender is a worthwhile opportunity? Okay, and why do you say you're ready?
Because I had time to sit down and think about like everything.
You had time to spend 6 months in a place you don't want to go back to.
Yeah.
Okay, all right. Well, Mr. Stokes, I will accept your offered plea. I will also sentence you as a first offender. So that thing that I told you about, you understand, an offered plea is still a conviction. This particular offered plea will not be a conviction, the felony one, because I'll sentence you as a first offender. You get to use it one time. This is it. So if at age 20, oops, I got in a fight and I bashed Ms. Grant on the head with her phone, you get arrested for that, and that's a felony, you don't get second offender. No such thing. Understand?
Yes, sir.
Okay. Mr. Stokes, I find there is a factual basis for both your pleas, the situation with Ms. Grant, the situation with the Cadillac. I also find that your pleas are knowing and voluntary. Voluntary means that you've decided, you've already told me this, but we're going to have to cover it again, that the right way forward for you, the thing that's in your best interest, is to enter these two offered pleas. Is that correct?
Yes, sir.
A knowing plea just means you've understood everything we've talked about. Do you have any questions about anything anyone said?
No.
Okay, then I'll accept your pleas. I'm sentencing you in the 23 SC 186018 case pursuant to the Probation Options Management Act. And all that means is that while you're on felony probation, if you have a small issue, you and probation will solve that issue. You don't have to come see me. But if it is a bigger issue, you get arrested again, or you don't do your community service or something like that, that's going to come back to me and we'll work through it. Mr. Stokes, do you authorize my staff to sign the indictment and the accusation in your two cases?
Yes.
Ms. Wood
Yes, Judge.
and Ms. Willingham?
Yes, Judge.
Okay, I think I covered those things. In 23 SC 186018, I am going to sentence you on count 1 to a term of 4 years to serve 180 days. Nope, let me say that differently. I'm going to sentence you to a term of 4 years to serve 6 months with the balance on probation. So you'll have 3.5 years of probation. Count 2 will be 6 months to serve, and count 5 will be 6 months to serve. Those will all run concurrently with each other. So it is 4 years to serve 6 months, also known as 180 days, but I'm measuring it in months, with the balance on probation, and you'll get credit for the time you served. Special condition of probation number 1, no violent contact with Ms. Grant. Now, it would be a crime to have violent contact with her anyway, but because I'm making it a special condition, even if it's misdemeanor violent contact, you shove her once. If you get arrested for that, remember this whole first offender thing. You could come back in front of me. I could revoke your first offender status and sentence you 5-10 years to serve. Probably not going to do that if all you did was push her. But if you lay hands on her in a way that she doesn't want, there will be bad consequences in this case. Understand?
Yes, sir.
Okay. Special condition number 2 is that you'll complete a family violence intervention program, which is a series of classes that will help you, and maybe Ms. Grant should go to one too, help her navigate how to handle the difficulties in life. It will be stressful having DeMarley around. He's going to be wonderful, but he's going to be demanding as well. He's going to cry and need diapers, and you're going to need to step up for that and do it in a way where you're not getting angry with Ms. Grant. You'll need to complete 60 hours of community service. You don't have to do that right away. And you'll need to get your GED during that time that you are on probation. I will table the question of restitution for now. And if Ms. Willingham wants to go forward with that, she can set a restitution hearing. You will get notice of when that's going to be from Ms. Wood. You can come back for that. The state would need to prove up that Mr. Sweeney is entitled to restitution for the busted window in his Cadillac. So we'll revisit that. And I will waive your probation supervision fees for the first 4 months of your probation. So you can get working, whether it's World Congress Center or construction or something different. You won't need to worry about paying those fees. You ought to be focused on making some money so that you can help take care of DeMarley. Ms. Willingham, anything else in connection with the 018 case? In 23 SC 187631, there's only 1 count remaining, and it has been reduced to criminal trespass, a misdemeanor. And in that case, I'm sentencing you to 6 months to serve. Those 6 months will run concurrently with your sentence in 018, and you'll get credit for all the time you serve. So there'll be no misdemeanor probation in the mix. It will all be felony probation through case ending in 018. Ms. Wood, anything else on behalf of Mr. Stokes?
No, Your Honor, thank you.
Mr. Stokes, it's Thursday. If you are not out by tomorrow afternoon, you should be reaching out to Ms. Wood so we can figure out what the holdup is.
Last time it took a whole month for my bunny update.
Say that again?
When you gave me a bun, it took a whole month for them to update.
Okay, this is different. This doesn't have anything to do with bond. I'm going to sign your sentencing orders today. They'll get transmitted and you ought to be released by tomorrow. But sometimes things don't move that quickly. So reach out to Ms. Wood tomorrow afternoon. I don't know how easily you can reach her, but if you can, if you let her know tomorrow afternoon, we'll have a chance to get you out before things shut down on Friday. Otherwise, it'll be next Monday. And I get the sense Ms. Grant is pretty anxious to get you back to help out with DeMarley. Before you go, we need to have Officer Sadler chat with you. She'll be on the screen, so you'll be looking at the screen about where to report and when to report for probation, okay?
Good afternoon, well, good morning, I'm sorry. Mr. Stokes, what's the address for where you'll be residing?
It's either gonna be 898 Washington Street, or I gotta get my dad address.
So you're gonna need to pick one now and commit to that at least
Right.
initially. So they need an address because they need to know where to find you if you don't report. Assuming you get out tomorrow, Officer Sadler is going to give you, you're probably going to need to show up for probation sometime next week. It's an early event. You don't miss that because they take out a warrant if you miss it. But they need an address where to find you if you don't show up. So today you need to commit to one of those two places. 2 weeks from now, if you want to move, you can do that. You just need to let probation know, hey, I'm switching to my dad's spot. Okay?
Yeah,
So
whatever address that you provide, because I know you said your dad lived in Jonesboro, and that's Clayton County, correct?
Yes.
Okay, so depending on the address that you provide to us will determine what office that you report to.
So which address do you want to start at?
898 Washington Street.
Okay, 898 Washington Street. And what city is that in? Atlanta? Do you have a zip code?
30315.
And is that your
Godmother's
that's your godmother's house? And she knows you could be there as early as tomorrow?
Yes.
Okay. Can you give Officer Sadler your godmother's name?
Joanna Reynolds.
You say that again. It's breaking up a little bit.
Joanna Reynolds.
How do you spell the first name?
YWANNA.
Okay. And then Reynolds?
Yes.
Okay. Do you have a phone number, or does Ms. Reynolds have a phone number?
She got a phone number, but I got to get out my notes.
Okay. How about Ms. Grant? What's a phone number where probation could call someone who'd be able to track you down?
404.
Is this your godmother's number or is this your number?
Nah, this is my uncle now. He's gonna be able to track me down all the time.
So what's your uncle's name?
Roderick Griggs.
Roderick
You said-
Griggs?
Roderick.
Griggs?
You said Griggs?
Yes.
And what is his number?
404-433-2561.
Say that one more time for me. The
404-433-2561.
433-2561.
Yes.
Okay, and you don't have a number for your godmother. You said her name was Yuwanda?
Joanna.
Yawana.
Yes.
And her last name was Reynolds?
Yes.
And you said you don't have a number for her, correct?
I don't have it on me. I got it wrote down in my notes. At the jail.
Okay. Okay, and let me make sure that the address is correct. Is 8901 Washington Street,
No.
Atlanta, Georgia?
No.
No? What was the
898
address?
898 Washington Street, Atlanta, Georgia, 30315.
898. Okay,
Yes.
I'm sorry. 898 Washington Street, Atlanta, Georgia. What's the zip code?
30315.
Okay. All right. Let me give you a report date. You will be reporting on June the 1st. You'll be reporting to 276 Memorial Drive, and that's Atlanta, Georgia, 30303. Hold on one second. You'll be reporting at 10 a.m. Okay. Do you have an email address?
Yes.
Let me get your email address, and what I can do, I'm giving you reporting instructions verbally, but I can also email you your paperwork, or I can send it to your public defender.
All right.
What's your email?
MAZZI
MAZZI.
CASH5@icloud.com.
Hold on, slow down. CH.
CASH.
MAZZICASH.
5@icloud.com.
She froze. I think there's a connection problem with probation.
Write this down here. Call me. June 1st is a Thursday. Okay, don't be late. 10 a.m. It's right down the street from here.
Yeah.
It's 276 Memorial Drive.
What is that?
What's your email? And I'll send it to her.
MAZZI
Okay,
CA.
cash.
Yeah. 5@icloud.com.
Okay. And I'll send it to Miss Grant too, okay?
All right.
I can forward all.
Great.
these.
All right. Officer Sadler, we'll get you that information through Mr. Stokes's lawyer. All right. Mr. Huey is on Zoom.
Good morning, Judge.
Morning. Let's get, are you gonna be, you'll be at council table? All right, let me remove that. All right.
What? I got to speak on.
Boy, I hope we're not waking you up this early, Mr. Huey.
No, sir. I was getting up already about an hour ago. Just took me a little longer time.
Yeah. All right. Ms. Wood, are you ready to go with Mr. Huey's case?
Ready, Judge.
And Ms. Willingham?
Yes, Judge.
Okay, this is 22 SC 183133, State versus Jerry Huey. Mr. Huey is appearing from somewhere other than the courthouse. Ms. Wood, his lawyer, is here in court, and Ms. Willingham is here in court as well. Mr. Huey, before we get started, two things. One, I need you to tell me that you are waiving your right to be here in court. You are choosing, which is fine, but you are choosing to appear from some other place. You all right with that?
Yes, sir. I am waiving it. Yes, sir.
Okay. The other right that you've got, you have a whole bunch of rights, but another right that you have is to have Ms. Wood next to you while we have this plea, so you can lean over and ask her a question or explain something to her. You guys are not in the same place. I can still connect you privately. Ms. Wood would just step outside. She can give you a call. Are you okay proceeding with you where you are and Ms. Wood here in court?
Yes, sir.
Okay. Will you let me know if you've got any questions for Ms. Wood so we can have her step outside and give you a call?
Yes, sir.
Great. Then we'll get going. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name, your age, and your date of birth. You can put your hand down.
My name is Jerry Bernard Hughley III. My age is 31. My birthday is 10/05/89.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am. Not at all.
How far did you go in school?
Always to the 11th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, I do.
By pleading guilty today, you are giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that counts 1 and 3 of the indictment will be non-pros, and you will enter a plea as to counts 2, simple battery, and count 4 and 5 amended to disorderly conduct, which is OCGA 16-11-39, for a sentence of 12 months as to each count, and each count will run consecutive or one after the other. Is this what has been discussed with you?
Yes, and I would like to talk to my lawyer a little bit about it, but yes, it's been discussed with me. Yes, ma'am. And I'm down. I'm with taking the plea. I just wanted to run it, didn't want too much probation, but yes, ma'am.
So are you asking Mr. Huey to speak with Ms. Wood right now, or you want to talk with her at some point before we finalize everything?
I would like to speak with her now, just to make sure that we got everything, the T's crossed and the I's dotted.
Judge, I think I know what he's talking about, and I think I can address it at the end.
Okay. Why don't we do this, Mr. Huey? Of course, you can speak with her in private. Why don't we get to just before I'm going to impose sentence, because you'll have had a chance by then to hear what Ms. Wood has to say, and she may well cover the things that you are curious about or concerned about. If she has not, then we'll take a timeout and you and she can talk before I finalize anything, okay?
Yes, sir. Thank you so much, sir.
All right.
You are pleading guilty today to simple battery and 2 counts of disorderly conduct, each with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is a total of 36 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 36 months to serve?
Yes, ma'am.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes, ma'am, I do know.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you will be required to complete family violence intervention program, complete a parenting class, no drugs or alcohol, and be subject to random screenings, complete 30 hours of community service, no violent contact with the victim, and no weapons. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am, not at all.
Are you satisfied with what your lawyer has done for you in this case?
No, not fully yet.
So what part are you not satisfied about?
I didn't want to take no parenting classes and none of that, Judge, because I know that I couldn't pay for a paid lawyer or have a court-appointed lawyer, and I know how this works. But I know that my son's mother was dead to the wrong and put these charges on me for something that I did not do, and I didn't want to take no classes, knowing that I just got a new job with my whole new family that I'm engaged to this beautiful one with now, and it's not gonna work for me trying to go to work, take these classes, and do probation. I ain't have to do this at all. I choose to do it just for the best interests of my child and my family.
Okay, so I hear you saying that you don't want to do classes, which would be the Family Violence Intervention Program. The question was, are you satisfied with the work your lawyer has done? I
figured not yet until we get. I don't want to take no classes because that's where I wanted to not do that, and I felt like it was absurd with too much probation. That's why I wanted to take it always to trial. But I just didn't want to pay taxpayers money, their dollars, to get a jury, get all these things, even though they might not go to trial with it because the case is so weak. But I really didn't want to take no lot of sentence or take no parenting classes, and for something that I know I didn't do.
Okay, so I guess I'll need to hear Ms. Wood's view as to how this should play out, and then we'll revisit this question about whether you're satisfied with your lawyer's work. We'll see if you and Ms. Wood need to speak in private, and I'll decide whether I even want to accept your plea. I may say no. I understand you're on the fence, but I may say, you know what, this is, if it's not gonna work this way, you just need to go to trial and take all that time out of your busy life, because that's what we'll need to do. And you would then face felony charges, not just misdemeanor charges. Why don't you keep going, Ms. Willingham?
Do you have any more questions for your lawyer before we go on?
No, not at this moment. We continue.
Have you understood everything I have asked you so far?
Every single thing, man.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, I will.
Is your decision to plead guilty made freely and voluntarily?
Yes, it's freely and voluntarily.
Did you in fact commit the offenses to which you are pleading guilty?
No, I did not.
Are you entering your plea of guilty pursuant to North Carolina v. Alford, meaning that you may not admit guilt to every element of the crime charged, but believe it's in your best interest to plead guilty today?
Yes, ma'am.
Are you a United States citizen?
Yes, I am, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. These are all misdemeanor offenses, so you will have 12 months from the date the sentence is entered. Do you understand these time limits?
Yes, I do, ma'am.
Should this case proceed forward to trial, the state would prove beyond a reasonable doubt that on July 11, 2021, officers responded to Greenwood Apartments 2891 Springdale Road, Atlanta, Georgia, in Fulton County, apartment 507, in reference to a dispute. Upon arrival, Sierra Scott stated that she had invited over a mutual friend of her and the defendant to see their new baby. When the mutual friend arrived, the defendant barged inside the home, smelling of alcohol, and had a beer bottle in his hand. He then picked up the infant and held him in the air with one hand. Scott became upset, at which time the defendant handed the baby to Scott's mother before punching Scott in the face with a closed fist. The defendant also grabbed Scott by the hair and threw her around the room, continuing to strike her. Two minor children, Jay Sparks, 11, and A. Gates, 9, were also present and witnessed the incident. The new baby was unintentionally struck during this altercation, as well as the victim's mother. And Your Honor, the state has offered this negotiated plea because in speaking with the victim in this, she would rather not move forward on this. She's been pretty persistent with that. In my last conversation with her, she asked me not to call her anymore. However, the state does believe that if we move forward based on the medical records of the child, that we could succeed as to the felony count on this indictment as well.
That would be the bruise to the child's head. That's what a hematoma is?
Correct, Your Honor.
Okay, meaning the medical records and photos would show that there was some injury sustained by the child, and the child's mother and maybe grandmother's testimony would be that Mr. Huey was acting in this erratic, potentially dangerous way. That's what the state thinks the evidence would show.
Yes, Your Honor.
Okay, understood. All right. What do you know about Mr. Huey's criminal history, if he has any at all? And I don't normally call on the state for that.
No, I know, Your Honor. It's okay.
We're operating without pretrial services today.
It looks like he has 11 cycles. it looks like he maybe received first offender as to a robbery, a disorderly conduct, and it looks like maybe he pled nolo to a battery, family violence. I'm gonna pull out the GCIC as well, Your Honor. I was looking at quick notes.
Okay, while you're doing that, let me turn to Officer Sadler. Officer Sadler, are you back with us?
Yes, Your Honor.
Great. What do you have for felony criminal history for Mr. Huey here in Georgia?
He has inactive probation that ended. He had a robbery offense from Clayton County. It was a first offender probation, and it ended March 16th of 2022.
So he was on probation for that when this happened. Was there any revocation from Clayton County?
1 second, Your Honor. It looks like he had a revocation on March the 18th of 2022. Let's see, it is ordered that the defendant has not been adjudicated. So they found that he had not been adjudicated guilty, and that he was to be released on time served and was to return to the original orders of probation.
Okay. All right. Thank you.
You're welcome, Your Honor.
Ms. Willingham, did you have anything you wanted to add?
No, Your Honor.
And what were the conditions of misdemeanor probation?
Complete the family violence intervention program. And Your Honor, I put parenting class in there because I wasn't sure if that was already embedded in the family violence intervention. Obviously, if it is, we would not be asking for both.
Okay.
No drugs or alcohol, and subject to random screenings because there was alcohol involved in this incident, and complete 30 hours of community service, no violent contact with the victim, and no weapons.
And there would need to be contact with Ms. Scott because they share a child?
Yes, and at the last time I spoke with her, she stated that for the purpose of their child, she did want some contact. Obviously, I have not talked to her in the last week.
Sure.
But when we last spoke, when we originally began negotiating this, that was her standpoint.
Okay. She didn't say it needs to be a third party. It
No.
would be, look, Mr. Huey can reach out because he ought to have access to his child.
Yes.
Okay. Got it. All right. Thank you. Ms. Wood.
Thank you, Judge. Mr. Huey has indicated to me that he has completely moved on.
Sounds like he's got a new life, new relationship,
Correct, Judge.
new
And
family.
when we spoke about this case, one of the reasons that he had indicated that he wanted to accept the state's new offer is so that he could put it behind him and move on with his new wife. We had discussed the special conditions that Ms. Willingham had imposed about the family violence class. And I believe what he was mentioning at the beginning is that he wanted me to ask the court to consider suspending the probation after successful completion of that program. But if he has something else, I'm sure he will address the court, Judge.
Okay. Mr. Huey, are you working these days?
Yes, sir, I am.
What do you do?
Me and my mother and my sister, we got our own cleaning service. We clean out apartments. We let them come in and do the demolition, repaint it, and we come in and just dust it and mop the floors and clean up the bathroom. They pay us $150 each unit.
So like you would get a contract for a whole complex, and as they're renovating the complex, you go
Yes, my
behind
sister.
them and clean them up.
Yes, sir. My sister and mother get the contract, and I'm just a mere worker.
A mere worker. Okay. Is your sister older or younger than you?
Actually, she's a year younger than me, and that right there get on my nerves.
All right. But she tells you what to do. All right. And you have how many kids?
I have 3. Yeah, I have 2 boys and a girl.
One of your kids is with Ms. Scott.
Yes, sir. Messiah Huber.
How old is he?
He's about to be 2, sir.
Okay, that's right, because he was a couple months old during this situation. Okay, 3 kids. How old is the oldest?
The oldest, about to be 8 on this month, May the 29th.
Okay,
Jerry. His name is Jerry also, sir.
Jerry Jr.
No, the 4th, Jerry Bernard Hughes the 4th. I'm the 3rd.
Wow, Jerry 4. All right. How long have you been working with your mother and your sister?
Actually, I've been working with them for the last 8 months now, maybe a little more, give and take, because it was started off as a little rocky first, but yeah, about 8 months to a year or so.
All right. How many hours a week do you work with them?
Shoot, let's say close to 40 hours a week. Yes, sir.
And your new residence and your new situation, is that in Fulton County or a different county?
We's in East Point, Georgia, and the address is 2206 Point View Drive, sir. Me and my wife,
Okay.
my future wife.
Future wife. When are you getting married?
She wanted me to get married around my birthday. I told her.
All right. An offered plea, Mr. Huey, is when a defendant like you says it didn't happen the way the state said it happened, but I want to move along, and I think it's in my best interest, meaning your best interest, to take this offer, which is now all misdemeanors, no felonies, and put it behind me. Does that describe your situation?
100%, Judge. Yes, sir.
Okay. You understand that it will still show up as misdemeanor conviction. So it's not a NOLO. I have a different view of the facts than the state, but it's still misdemeanor convictions. You understand?
Yes, sir. Yes, sir.
Do you authorize my staff, Mr. Huey, to sign the indictment indicating your offered plea?
Yes, sir. They can sign it. Yes, they can.
Ms. Wood?
Yes, Judge.
And Ms. Willingham?
Yes, Judge.
All right. Mr. Huey, I find that there is a factual basis for your plea. I understand that you are saying it didn't happen like Ms. Scott said it happened, and you're entitled to a different view on it. But if Ms. Scott came in and her mother came in and there were medical records presented or photos, a jury could, not saying they would, but they could decide that the state had proven all these charges against you. So I'll accept the plea. I also find that your plea is knowing, meaning you've understood everything, and voluntary, meaning no one has forced you to do this. You've decided that it's the best way to move forward for you. Do you agree with that?
Yes, sir.
All right. Your turn. Tell me what you want to tell me, if you want to tell me anything about this situation. And to be clear, that question was a little broad. I'm not asking you so much to give me your version of events from July of 21. I just know there were a few things you had wanted to talk about with Ms. Wood. She has shared with me some of the pushback you had on the state's recommendation. And so I just want to make sure, either if you want to talk with Ms. Wood, now's the time for us to do that, or if there are things you want to share with me, now's the time to do that.
Really, I would like to talk to Miss Wood, sir, because everything I told you, I'm gonna remind Miss Wood. Also, I just didn't want her to take too much out of my life, and for me to stop the things that I need to do for my kids. And I'm 34 years old this year. I'm too grown to be doing parenting classes and stuff like that, because I already done it before. If you look into my record,
why would you have taken parenting classes before?
Okay, in Clayton County, I had got a false accused for robbery for something that I did not do. They had me sitting there for 28 months, and then they eventually found the guy who done it. But the whole time I was sitting there, everyone in our cul-de-sac, and our dorm had to take chess classes, or school invention classes, or parenting classes, and I took parenting and chess.
Okay. Boy, you seem to get accused of a whole lot of things you haven't done. You got some bad luck, Mr. Huey.
Yeah, back then.
So
I was in the wrong neighborhood at the time, sir.
Guess what we need to do is pause, and Ms. Wood's going to step outside. I don't know if you've got a second phone or if you should drop off the call right now, Mr. Huey, but Ms. Wood's going to call you, and then you just pop back on the Zoom, okay?
Yes, sir. Thank you so much.
The first question I asked was, does that mean I'm moving out of judgment?
Well, thank
And
you
they said,
for
no, you can stay.
pushing back. That would have been a loss to us and totally disruptive given how many cases you've got. So I'm glad you're staying put for now. I've come to accept as a sad fact of life that these units rotate a lot. But longevity is you can always hope for it.
Judge McBurney,
Yes, ma'am.
this is Sadler, probation.
Hey,
By chance, did anyone get that email address from Mr. Stokes when he was calling it out? The computer froze up and I was unable to get the email address to send him his reporting instructions.
yep. So Ms. Wood has it, his lawyer, and she's going to send it to you.
Okay, great. Thank you.
Sure. And you are free to go if you want. Mr. Huey is getting misdemeanor probation, so he's not going to be reporting to any of your colleagues.
Okay, thank you.
You bet. Thank you for helping out today.
No problem. Have a great day.
You too. All right, Mr. Huey, you're on mute. You'll need to unmute. I muted you just in case we could hear what you were saying. We didn't want to do that. It was a private conversation. Ms. Wood, did you and Mr. Huey have enough time to speak?
Yes, Judge.
Okay. Well, once Mr. Huey unmutes, we'll pick up where we left off.
Okay.
He's back. Mr. Huey, did you have enough time to speak with Ms. Wood?
Yes, I did, sir.
All right. You ready to go forward?
I would like Miss Woods to speak with you, because she know how to tell you exactly what me and her planned on doing,
Okay.
and how she think what's best for my interests.
Got it. Let me hear from your lawyer and your advocate. Ms. Wood.
Thank you, Judge. Yes, after speaking with Mr. Huey, he is concerned about his ability to complete the family violence intervention program due to this new job that he has and taking care of his children. I advised him that we could ask the judge to not impose that special condition, but that it is up to the court and that we had previously discussed it with Ms. Willingham. So he's asking that you not impose the family violence intervention program as part of his probation on this case.
Okay. Got it. Mr. Huey, I appreciate you sharing that. Appreciate the new situation you're in. In your case, I'm going to sentence you on count 2 to 12 months, count 4 to 12 months, and count 5 to 12 months. Those will run consecutive to each other. So that's a total of 36 months. They will all be probated. Your special conditions of probation are: number 1, no violent contact with Sierra Scott. Number 2, 60 hours of community service. And number 3, for the first 6 months of probation, you will have 2 random drug and alcohol screens each month. Your probation can be suspended after the first 12 months if you finished all of your community service and there were no issues with the drug screen. So if you are doing fine and you're gainfully employed and you've done the community service, then after 12 months, you can petition, meaning ask to have the rest of your probation suspended, which would mean there's still 2 more years that you're technically under sentence, but you're not reporting to anyone, you're not paying any supervision fees. It's just if 13 months from now, you were to get into trouble, you touch Ms. Scott the wrong way, the state could seek to basically revoke the suspended months, but you're not having to report anywhere or do anything else. Ms. Willingham, do you have any, I know I didn't impose FVIP. That was a conscious decision. Anything you want to add to Mr. Huey's situation?
Nothing further, Judge.
Ms. Wood, any questions?
No, Your Honor.
All right. Ms. Nelson, Mr. Huey is not here, so we're not going to have misdemeanor probation come to court to meet with Mr. Huey. What instructions do we need to give him about meeting with misdemeanor probation?
I'll send that information to Ms. Wood and she will complete the form and probation will reach out to him.
Got it. Mr. Huey, you're going to get a call or an email or something from misdemeanor probation where they tell you, we need to meet with you for this kickoff meeting on this day at this time. You do not want to miss that meeting because if you're not there, then they tell me he's a no-show, he's absconded, please sign this warrant, and you go back to jail. So make sure you don't miss that first meeting. And then they'll set up the frequency with which you're meeting with them and talk to you about the very few requirements that I imposed. Do you have any questions about any of the things I just discussed?
Not at all, Judge. Thank you also for helping me too, sir.
Well, I want you actually to help yourself by starting out in this new relationship and heading in the right direction. Like you said better than I could, you're in your 30s now. You need to be done with getting locked up and being pulled away from your family. And I hope that happens, but you decide that. I don't. All right. Thank you,
Yes, sir.
everyone.